An attachment of earnings order is a legal tool that allows the court to connect the maintenance order to the party's bank account. This means that the maintenance payments the breaching party owes will be automatically deducted from their salary and bank account and sent to the other party's bank account. Think of it of something like an automatic bill payment of your utilities or rent. So how long does maintenance usually last? When a court in Singapore issues a maintenance order, it means that one party in a divorce or family court case is legally required to provide financial support to the other party as decided by the court. This support could be for a spouse or for children. If someone doesn't follow this court order, it's considered a breach and there can be serious consequences. When the party responsible for making maintenance payments doesn't follow the court's order, the other party has the right to take action. They can apply to the court to enforce maintenance arrears or request an attachment of earnings order. The duration for making maintenance payments is usually specified in the court order itself. It can last until certain conditions are met, such as when the children turn 21, the recipient's spouse remarries, or when there's a death. However, it can also be modified if there's a valid reason. Sometimes the circumstances of the parties involved change significantly after a divorce. Singapore's courts understand this and allow for changes for a maintenance order to be made when there's been a substantial and material ongoing change in someone's situation. This change can't be something minor, and it must be substantial, material, and ongoing. Examples include some of the following: becoming bankrupt, severe medical conditions, a significant increase or decrease in income, the sudden acquisition of significant wealth. The Women's Charter gives the court the power to make changes when it's satisfied that there has been a material change in the circumstances. So how do you know what counts or what doesn't count as a material change? It's important to note that a change in circumstances cannot be self-inflicted. For instance, someone can't intentionally reduce their income or financial health just to avoid paying maintenance. Similarly, the person receiving maintenance can't use extravagant spending as a reason for increasing the maintenance amount. So how then do you apply for a variation of the maintenance? To request for a variation of the maintenance order, you need to make an application to the court. This application should be submitted as a summons with a supporting affidavit, which should also include your explanation and details about why you want to change the maintenance order, and it should be backed and supported by relevant evidence and documents. How does the court decide how to vary the maintenance? When deciding whether to vary a maintenance order, the court follows similar principles as when it initially decided on the maintenance amount in the first place. The court considers all the facts and circumstances of the case and evaluates the reasonableness of the request. The critical difference is that the court now considers the changed circumstances of the person requesting the variation compared to when the original order was first made. So now you know. If you found this helpful, follow and subscribe to our channel for more legal things.